A very good morning to one and all. I myself, Dr. Yogesh Mahajan, working as an assistant professor in S.S.Maniyar Law College, Jalgaon, would like to give my presentation on the topic of the sexual harassment of women at workplace prevention, prohibition and redressal act 2013. This is a very important law which protects the dignity of the woman. The introduction I would like to say about this law. The Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, is an international treaty adopted in 1979 by United Nations General Assembly. It is described as an international bill of rights of women. It was instituted on 3rd September 1981 and has been ratified by 189 states, and India is one of the signatories and ratified on 25th June 1993. Fundamental rights and Indian Constitution form the basis of this law. As we know, the constitutional doctrine of equality is contained in Article 14, 15 and 17 of the Constitution of India, which promotes the concept of equality, and it says that there should be equality between man and woman. And for that purpose, this law has been enacted, as well as Article 21, which deals with right to life and personal liberty, which also says that right to life with dignity includes the right to livelihood, and women should be given the protection of dignity as per this article. Article 19(1)(g). In that context, one of the leading judgment is Vishaka's judgment. Vishaka versus State of Rajasthan. This is the most important in this context, wherein the Supreme Court has given the guidelines relating to sexual harassment of the woman at workplace. Sexual harassment of women at the workplace is the violation of the fundamental freedom of all women as citizens to pursue the business, trade, or profession of one's choice. If a woman is working in any place of employment, she should not be harassed sexually. At that workplace, there should be a smooth and proper kind of atmosphere, and if it is not being given to the particular woman, it is a violation of basic fundamental freedom where she cannot exercise a proper business, trade, profession, and if such is the case, Supreme Court has given various guidelines for the protection of dignity of the woman. Thereafter, we are going to discuss about the provisions of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. The Act received the assent of the President on 22nd April 2013, and it came into force on 9th December 2013, and it is applicable to the entire territory of India. There are various definitions given under Section 2. Section 2 Clause N defines sexual harassment. What is sexual harassment? It includes any one or more of the following unwelcome acts or behavior, whether directly or by implication, namely physical contact and advances, a demand or request for sexual favors, making sexual colored remarks, showing pornography, or any other kind of physical, verbal, or non-verbal conduct of sexual nature. This is the definition which is given under Section 2. Section 2A defines aggrieved woman. Who is the aggrieved woman? Section 2A says that it means in relation to a workplace a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent. In relation to a dwelling place or house, a woman or any of any age who is employed in such a dwelling place or house. Appropriate government definition is given under Section 2 Clause B, which says that in relation to a workplace which is established, owned, controlled, or wholly or substantially financed by the funds provided directly or indirectly by the central government or union territory, that will be the central government. In any other case, there will be if it is by the state government, the state government. The district officer section under Section 2 Clause D defines district officer, and it is saying that the appropriate government may notify a district magistrate or additional district magistrate, collector, deputy collector as a district officer to exercise the power and discharge the function under this act. Workplace definition is given under Section 2 Clause O, which says that it includes any department, organization, undertaking, establishment, enterprises, institutions, and offices financed by the government or any local authority. It may also include a private sector, hospital, nursing home, any sports institution, stadium, training center, or any place visited by the employee out of or during the course of employment, or a dwelling place or house. Prevention of sexual harassment is discussed under Section 3. No woman shall be subjected to sexual harassment at any workplace. The following circumstances, among other circumstances, if it occurs or is present in relation to or connected with any act or behavior of sexual harassment may amount to sexual harassment, such as implicit or explicit promise of preferential treatment in her employment, implied or explicit threat of detrimental treatment in her employment, implied or explicit threat about her present or future employment status, or interference with the work or creating an intimidating or offensive or hostile work, and humiliating treatment likely to affect her health or safety. These circumstances will fall within the purview of sexual harassment. If any employer is giving such kind of treatment, that conduct will amount to sexual harassment, which is given in section 3. Section 4 is telling with the constitution of ICC, that is Internal Complaint Committee. Every employer has to constitute by an order in writing a particular committee that is called as what? Internal Complaint Committee. And according to this committee, the composition is being given wherein that a presiding officer shall be a woman at a senior level at a workplace amongst the employees. From the employees only, the woman who is a senior in rank, she will be the presiding officer. In any other case, there will be the presiding officer in any administrative unit of the work that will be nominated by the particular employer or that kind of organization. Not less than 2 members will be there from amongst the employees preferably committed to the cause of women who had experience in such legal knowledge. 1 member from amongst the NGO thereafter who is being dedicated to the cause of the women relating to sexual harassment, provided that at least one half of the total members shall be a woman for the redressal of grievance of women, and they shall be nominated. They shall exercise the tenure for a period of 3 years. Then constitution of local complaint committee. In any kind of department or institutions where there are less than kind of particular kind of members, less than 10, there will be the district officer shall constitute a committee that is called as what? LCC, that is given under section 6. Where less than 10 members are working, then the committee constituted is the LCC, that is a local complaint committee. The district officer shall designate a nodal officer in every block, tahsil, taluka, or tribal area, ward, municipality to receive the complaints to the concerned LCC within a period of 7 days. The jurisdiction of LCC shall extend to the areas of district where it is being constituted. That is local complaint committee. Then composition tenure shall be such as we have discussed before. That shall be a chairman shall be there who is dedicated to the cause of the woman. 1 member to be nominated from amongst block of taluka, tahsil, etc. and 2 members of whom one shall be the woman. That is constitution of local complaints committee. It is also provided that one of the nominees shall be a woman to SC, ST or OBC or minority community that will be appointed by the government from time to time. The chairperson and every member of LCC shall hold office for such period not exceeding 3 years from the date of appointment as may be specified by district officer. Complaint of sexual harassment. This is very important. Under section 9, the provision discusses that if any aggrieved woman, she is an aggrieved woman, she is a sufferer, she will make a complaint in writing of sexual harassment at workplace to the ICC Internal Complaint Committee or LCC where there is no ICC if it is not constituted, and that is to be made within a period of 3 months from the date of incident, and in case of series of incident within a period of 3 months from the date of last incident. If such complaint cannot be made in writing, the presiding officer or any member of ICC or the chairperson or LCC shall render such reasonable assistance to the woman for making the complaint. It is a duty of the concerned persons, that is the presiding officer, that they should give the assistance to the woman to make the complaint. Where the aggrieved woman is unable to make a complaint on account of a physical or mental ability, the legal person, legal hires on behalf of her, they can also make a complaint. Conciliation. After the complaint is being made, inquiry will be conducted and there will be the steps that has to be taken to conciliate between the two persons, and that conciliation shall not be a monetary settlement. The settlement shall be recorded and forwarded to the concerned authorities. Copy of the same shall be given and there shall be no further inquiry. Inquiry into the complaint is discussed under section 11, which says according to the provisions of section 10, the ICC or LCC shall proceed to make an inquiry into the complaint in accordance to the rules. It is further provides that if the aggrieved woman informs that any term or condition of the settlement arrived has not been complied with the respondent, then the ICC or LCC shall proceed to make an inquiry into the complaint. If there are no means of conciliation, settlement, then inquiry will be done. And notwithstanding anything contained in section 509 of the IPC, the court may, where the respondent is convicted of an offence, order payment of such sum as it may consider appropriate to the aggrieved woman by respondent having regard to the provisions of section 15, that is section 11. For the purpose, we can say that whatever the matter is being investigated, inquired, all the powers which are given under the CPC, like summoning, enforcing, attendance of the witness, requiring discovery and production of documents, all such measures which are given under the Civil Procedure Code, the concerned authority will have the powers of civil court as per the Civil Procedure Code, and this inquiry has to be completed within a period of 90 days. Inquiry into the complaint action during pendency of inquiry. During the pendency of inquiry on a written request made by the aggrieved woman, the ICC, LCC, or as the case may be, recommend to the employer to transfer the aggrieved woman or the respondent or any other workplace. Grant leave to the aggrieved woman for a period of 3 months and grant such relief to the aggrieved woman as may be prescribed. The leave granted to the aggrieved woman under this section shall be in addition to the leave as she would be otherwise entitled. On the recommendation of the ICC or LCC, as the case may be under the subsection, they may implement the recommendation and also send the report to the ICC or LCC as the case may be. Inquiry report is given under section 13. On completion of inquiry under the Act, the ICC or LCC shall provide a report of its finding to the employer, the district officer, within a period of 10 days from the date of completion of inquiry, and such report shall be made available to the concerned parties. Where the ICC or LCC arrives at a conclusion that the allegation against the respondent has not been proved, it shall recommend to the employer and DO that no action shall be taken in the matter. Where the ICC or LCC arrives at the conclusion that the allegation against the respondent has been proved, it shall recommend to the employer or the DO as the case may be. Take action of sexual harassment as a misconduct in accordance with the provisions of service rule applicable to the respondent, or where no such service rules has been made in such manner as may be prescribed, to deduct, notwithstanding anything contained in the service rules applicable to the respondent, from the salary or wages of the respondent such sum as it may consider appropriate to be paid to the aggrieved woman or to her legal heirs as it may determine in accordance with the provisions of section 15. Provided that in any case the employer is unable to make such deduction from the salary of the respondent due to his being absent from the duty or cessation of employment, it may direct to the respondent to pay such sum to the aggrieved woman. Provided further that in case the respondent fails to pay the sum referred to in clause 2, the ICC or as the case may be LCC may forward the order for recovery of the sum as in arrears of land revenue. The employer or the DO shall act upon recommendation within 60 days of the receipt of its received by him. Punishment for false or malicious complaint is given under section 14, where the ICC LCC arrives at a conclusion that the allegation against the respondent is malicious, or aggrieved woman or any other person making the complaint, knowing it to be false, or aggrieved woman or any other person making the complaint has produced any forged misleading document to the employer or DO, take the action against the woman or the person who has made the complaint under subsection 1, subsection 2 or section 9 as the case may be in accordance with the provision of the service rule applicable to him or her, and where no such service rules exist in such manner as may be prescribed. Provided that a mere inability to substantiate a complaint or provide adequate proof against the complaint will render under this section. Provided further that the malicious intent on the part of the complainant shall be established after an inquiry in accordance with the procedure established, which is recommended. Where ICC LCC arrives at a conclusion that during the inquiry any witness has given false evidence or produced a forged misleading document, it may recommend to the employer or the witness of the DO to take action in accordance with the provision applicable to the said witness, or where no such service rules exist as such manner as may be prescribed. Determination of compensation is given under section 15, which says that compensation may be determined as per the mental trauma, pain, suffering, emotional distress, loss in the career opportunity due to the incident of sexual harassment, medical expenses, income, and financial status of the respondent, feasibility of such payment in lump sum or installment. So these are the important relevant provisions of the prevention of sexual harassment. As we have seen that what is sexual harassment, what are the definitions, how the committee is to be constituted, and what steps have to be taken, how inquiry is to be done, thereafter what procedure has to be followed, and how the remedy is to be given to the concerned woman. These are the important basic provisions of the prevention of sexual harassment of the woman at workplace. And if any woman is a victim of sexual harassment, as per these measures they can take and they can protect the dignity of the women. Thank you for this patient listening.